Case number 116550, State of Kansas v. Casey Nesbitt.
May it please the Court, Kimberly Streit-Vogelsberg of the Appellate Defender's Office, appearing on behalf of Casey Nesbitt. I would request 3 minutes for rebuttal.
3 minutes is granted.
Thank you. To summarize the facts of this case, MS was 100 years old and she lived home alone. One morning, a man entered her home and raped her. She was hospitalized for 15 days and was in pain due to a fractured vertebrae in her lower spine. That pain reduced her mobility, and instead of being released back home, she was released to a nursing facility where she passed away 6 days after that. The autopsy determined the cause of death was a pulmonary blood clot, which originated from the clotting in her legs, which was due to her immobility, which was caused by pain. The doctor admitted that it was possible she would have developed those clots regardless of the assault. DNA testing pointed to Mr. Nesbitt as the perpetrator, but there was no other physical evidence or testimonial evidence that supported him being the perpetrator other than that DNA evidence. After a trial, jury convicted Mr. Nesbitt of felony murder, rape,
Counsel, could I ask you one fact question?
Sure.
There were 2 different samples of his tested, correct? There was one from the past, like 2002, and then a contemporaneous one taken after he was arrested. Is that correct?
I actually do not know.
Okay. All right.
I prepared for this case off of the briefs.
I appreciate that you're pinch hitting.
So I'm sorry that I cannot answer that.
Okay.
I'm happy to look it up.
My understanding was the testimony was that the odds were 1 in some kind of quintillion or something like that.
Yeah, 1 in 3.34 or something quintillion,
Okay.
yes.
Thank you.
He was convicted of felony murder, aggravated burglary, and received a life sentence without the possibility of parole for 25 years and a consecutive prison sentence. So the first issue is the sufficiency of the felony murder charge. I would suppose that because the death was too far removed from the rape in both time and in causality, that this court should reverse. The death did not occur within the res juste of the crime, and nor was the death a direct result of the crime of rape. There was...
Now, I understood that you were saying that victims sustained broken vertebrae as a result of the rape. Is that true?
Yes.
Okay. And then because of that, she was immobile. And because of her immobility, she developed blood clots in her leg that then went to her lungs that then killed her.
Yes.
And what was the extraordinary intervening event that superseded it between Mr. Nesbitt's injuring her and her death?
Well, I think in this case, certainly you have cases where there is some giant act that happens. But I think in this case, you have a domino effect. And when several of those dominoes one, you have the overarching issue of time. There's 21 days there's 21 days between these two events, and there's so many steps, and several of those steps are her pain and immobility. And I think you could argue, I do argue, that with pain, there's an issue of subjectivity. Not all people feel pain the same way.
But you take your victim as you find him.
Right.
You take, instead of a Olympian, you have a 100-year-old woman, you have to deal with that. And if she is more likely to be immobile, less tolerant of pain, or develop blood clots, that's what the defendant has to accept.
You do have to accept the victim, and that's why if you look at the cases where there's a drug sale and a death occurs from an overdose, that person was likely a drug addict, but yet their overdosing was a sufficient break in that causal
Because
chain.
they had to do something voluntarily in between the time of the crime, when the drugs were acquired, and the time of the overdose death. The victim himself or herself had to do something voluntarily.
And
We don't have evidence of anything like that here.
I think there's a similarity in the fact that her lack of mobility wasn't for certain. There was some element of control. It wasn't as though she was in a full body cast and was
But she
completely
had a broken
prohibited.
wrist as well and bruising from head to toe, according to the nurse examiner, correct?
Yes. So while her injuries were
Also artifacts of the rape and battery that accompanied it.
yes. So I think, obviously there's a continuum of cases, and while this case certainly isn't the exact same as the drug example that I gave you, I still think it falls on the line of there was enough subjectivity and enough control in some of these steps that when you combine that with the amount of time, we don't have a felony murder.
Which step was extraordinary?
I think the combination of those, how many steps that there were, are together in an extraordinary event.
Why isn't this just a jury question?
Sufficiency of the evidence?
The cause and effect of the death.
Well, the issue is sufficiency.
I understand that,
Yes.
but why wasn't,
And certainly,
got an old woman, she was raped, she goes to the hospital, she's immobile, she dies, coroners testify, people testify, and they say this is the reason why she died. Well, why wasn't that just a jury question?
well, if it was always just a jury question, we would never reverse for insufficiency of the evidence after a jury verdict. I think sometimes juries don't understand the nuances of these legal arguments, and I think when you have but-for cause, where certainly the rape instigated this chain of events, a jury could find that that was cause without understanding all the legal ramifications of these arguments, and that some of these steps, there's other elements, and with the time, that legally it doesn't provide cause, even though factually there is but-for cause.
We have lots of medical malpractice cases. We had one last docket where the woman died a year later, and the issue was but for causation, and how you talked about that. I'm just trying to figure out whether we aren't substituting our judgment about what caused the woman's death.
I don't think that you're doing that because the jury wasn't. It's a legal question and not a factual question. I think in this instance.
Why is then, as a legal question, why is as a matter of law, we can say that her death was not caused by the injury that started the chain of events? How, as a matter of law, we can say your client caused the injury that ended up through a series of events causing she died? What is there as a matter of law? Usually extraordinary intervening events would be a medical malpractice or a fell out of bed in the hospital, or something that would have intervened in the chain of causation. And so what is it here that we can say as a matter of law?
I think it's the element of patient control. I would ask you to consider slightly to highlight these facts in this argument. If you had a rape victim who was raped and was very upset by that and became very depressed, and as a result of the depression, quit moving as much, and as a result of that, got a blood clot, which then traveled to her lungs, and 1 year later died, would that be the result of a rape? Would that be a felony murder? And I think the answer there would be no, for the same reasons that are here in this case, because there is an element of patient control. And now, obviously, in this case, it's smaller than the example I just gave you, but I still think that it falls on that side of the line where we have to say that that is enough to break that chain.
What
We
is
have
the
had-
what is the patient here controlling about her condition?
I think it's her mobility. She was in pain, and that pain caused her to avoid pain. She essentially chose not to move. She became immobile. I think there are other things that a patient could do to become mobile, or perhaps, like I said, pain is somewhat subjective. Certainly some victims would have the ability to choose whether or not to move, and that is an element of control.
And the pain, as I understand it, was attributable to her broken vertebra and her lower body injuries. Is that right?
Yes.
Which the physicians testified was the cause of your client.
Yes.
Right.
I am not saying that there's not a but-for cause. Certainly all these events are related, but when you also have the subjectivity of pain and her control over of her body's movements, I think that that's enough to break that in this case, and that is our argument.
We have had case law that says malpractice by a treating physician after a felony felony causes injury doesn't break the chain of causation. That the defendant is still liable for a death, or even if there is that malpractice that may have contributed to the death. How is that case law distinguishable from what you're arguing?
Because here there's the subjectivity of as it relates to the victim, and there's a decision in there, and it seems as if someone else has control of an outcome, and this isn't
Doesn't the physician and treating physician have control of the outcome?
I think that's different when it's the victim's control versus some outside
Why?
force.
Explain that to me.
I'm not. I think it matters because, and maybe I'm not sure, Your Honor. I would just fall back upon the argument that because there's so many steps, it's not just one mistake of a physician. There's so many steps in this case, and at least two of them have some degree of patient control or subjectivity, and I think that's enough to distinguish that from one act of an outside physician.
So crime victims have a duty to mitigate the damages imposed on them by the criminal.
Certainly, I am sympathetic towards any victim and do not wish to blame any victim. I just think the facts of this case are such that there's insufficient evidence that that death was directly caused. Would not go so far as to say there's an affirmative duty. If there's no questions on that, I would conclude my remarks until rebuttal.
Any more questions?
Can I ask her briefly on your issue 4 on the race switching instruction?
Please.
Was there anything that would preclude a defense argument without the instruction to tell the jury, I'm thinking of a time to kill,
Yeah.
the closing argument is, imagine the victim was a different race, or imagine is there anything that would preclude that, making that argument to the jury, even if you didn't do the rather detailed instruction that was requested?
Well, if the answer is no, the argument is not precluded. I think that supports the contention that that the instruction was not legally inappropriate. If it's legal to discuss that, then it should be legal to give the instruction. And if it is somehow prohibited, then I think it highlights the need for the instruction to make sure that that kind of racial bias does not occur.
Any more questions? Thank you, counsel.
May it please the court, Assistant District Attorney Leslie Isherwood, appearing on behalf of the state. Justice Beyer, I did want to address your question first. It's my understanding from the record that there were two DNA tests done, and my understanding is that that was for the sake of the integrity of the investigation because of the dated.
And that was
sample.
testified to in front of the
That
jury?
is my understanding.
Yeah. Okay, thank you.
We will primarily focus our argument on the first issue, but obviously we'll take questions from the court with respect to any of the other 4 issues that have been raised. The first issue, sufficiency of the evidence to support the defendant's conviction for felony murder. We look at this in the evidence that's in the light most favorable to the state. In order to establish felony murder, the state was required to prove 2 elements of causation: that it must lie within the res gestae of the underlying felony, and also that the felony and the homicide must have a direct causal connection, and that that felony is the sole legal cause of death. The defendant's specific contention is that the fact that MS did not pass away until 21 days after the sexual assault, that death was too remote in time to be considered part of the occurrence of rape in order to support the conviction for felony murder. The law does not stand for the proposition that the death and the felony must occur simultaneously. In fact, under the felony murder rule, the killing may follow the rape as long as there is a continuation based on time, place, and continuity of action that makes that felony the legal cause of MS's death. In this case, the rape that the defendant perpetrated against MS set in motion a chain of events that continued to occur until the point in time in which she died. He brutally raped her. That attack caused horrific injuries both to her genital region and as well as a fracture to her lumbar spine. MS was active and independently mobile prior to this attack. As a result of those injuries, the pain was nearly intolerable to where it was almost impossible for her to move, and certainly was not possible for her to move without the assistance. So she was stripped of that independent movement. She essentially became bedridden as a result of the pain of the injuries. That sedentary state resulted in the formation of blood clots. 3 to 7 days after those blood clots formed, they broke free, traveled to her lungs, and she ultimately died. The injuries inflicted by the defendant as a result of the rape triggered her deterioration and basically instigated a slow death that MS suffered as a result of the rape. The mere passage of time does not absolve the defendant of criminal liability for felony murder under the facts of this case. It would remain the state's position that there is sufficient evidence to support the defendant's conviction for felony murder when that is reviewed in the light most favorable to the state.
Is any part of that chain or at any point along this question of causality, is there a purely legal question?
I think the only purely legal question is whether that felony that was committed was the sole legal cause of her death.
And I guess what that's getting at is what Justice Biles asked earlier, which is, why isn't this, it's raised as a sufficiency question, and so it seems to me the question for us is, could any reasonable juror have convicted on this evidence?
And I think that's essentially...
And if that's the case, then there's no purely legal question for us to answer.
I think that's embodied within the sufficiency of the evidence consideration, if that answers your question. With respect, I will touch briefly on issue 4 with respect to the jury instruction that was
Ms.
requested.
Isherwood, before you
Yes.
leave issue 1, counsel didn't really focus on the res gestae aspect that you talked about initially when you said what the state needs to demonstrate for felony murder. Could you maybe flesh that out a little bit more than the causation?
As far
Is
as
it, what needs to be within the res gestae? What act of the defendant? It's the rape, isn't it?
it's the rape that needs to occur within the res
Which
gestae.
it certainly was here.
Right.
Okay. What's the effective passage of time on res gestae, if any?
I truly, I don't believe there is an effect. I mean, if her injuries had resulted in her being in a coma, do we allow her to languish, but only a set period of time? And if you are, resuscitated from your coma one day after that time, well, I'm sorry.
You're out
that-
of luck.
yeah.
Okay. Thank you.
Sure. The fourth issue challenges the court's denial of the defendant's requested race switching instruction, and this court looks at that whether it was properly preserved, whether it was legally appropriate, and whether it was factually appropriate. Given that it was requested and objected to, the state would maintain that it was properly preserved. With respect to whether it is legally appropriate, it would be the state's position that race generally has no place in jury deliberations in a case of this nature. The instruction that the defendant was requesting was essentially injecting race into the trial, but then telling the jury not to consider it. Here, the instructions issued by the court properly advise the jury what the framework is that should guide their deliberations, that the verdict must be founded entirely on the evidence, that the evidence that they use consists of witness testimony, exhibits that have been admitted into evidence, admissions and stipulations, that it's their role to assess witness credibility, that the defendant is innocent until proven guilty, and that the state has the burden to prove his guilt beyond a reasonable doubt. The fact that race did not play a role was embodied within those instructions by virtue of its absence. Had that been a proper consideration for the jury, that would have been included in the framework that the court provided. Was it factually appropriate? Absent a particular need, under the facts of the case, this court has advised that PIC instructions are to be followed and should not be deviated from. An instruction of this nature could conceivably be appropriate if this court were to find that it was legally appropriate in a factual situation where it's more amorphous, where there's eyewitness identification or where there's a photo array. That is not this case. This is a science case, a DNA case. Race did not even play a role. It was the defendant's DNA that linked him as the perpetrator in this case, whether it was harmless. The component should be addressed in the event this court were to determine that error did occur. The error is reversible only if there's a reasonable probability that the jury would have returned a different verdict had that instruction been issued. I've previously summarized the evidence, but with respect to the jury instructions, which is also part of the package we have to consider, they were properly informed of the essential elements of the offense. They were properly informed of the government's burden of proof, and they were told that the law demands a just verdict that's based on the evidence alone and no other considerations. Any error then associated with the refusal to give this instruction should be deemed harmless because there's no reasonable probability the jury would have returned a different verdict had this instruction been given.
Let me back you up on that argument, and I've got to confess I was doing some research on that issue.
Well, that's
and
not
and I
fair.
missed, I think, the beginning of what you said. On the race switching instruction that was requested, did I understand your position was that it wasn't factually appropriate
Yes,
in this case, and that's because of the nature of the evidence?
correct.
It doesn't just have to do with the race of the defendant or the parties that are the people that are involved.
Correct. Under the facts of this case where the only consideration is the DNA and the DNA doesn't speak to the racial differences of the parties, that would not be factually appropriate in this case.
Okay.
Are you done with that issue?
Sure.
The prosecutorial error in closing argument,
Yes.
the one I want to ask you about is the reference to the 100-year-old family member that appeared to be a gift to this family. They kind of treasured this kind of thing that they had. On the one hand, I appreciate that a prosecutor would want to talk about the age and vulnerability of this particular victim. But first of all, does it cross the line to talk about what a treasure she was to the family?
Well, I think obviously we have to first start with, whether error occurred.
Right.
And I think also in a prosecutorial error case, you have to determine the record as a whole. The state's theory in this case was that obviously she was active, she was independent prior to the time of the attack, and it's her deterioration after the attack that results in her death. All of the evidence that was properly admitted supported that theory. When we look at the first part of the state's closing argument, it was a summarization of that evidence, and it was an extensive summary of that evidence. When we look at the rebuttal closing, it was primarily devoted to the what investigators played a role in this crime and what evidence they contributed as a result. These last few statements, as far as, I've got them here in front of me, a 100-year family member appeared to be a gift to this family. They kind of treasured this kind of thing that they had. They had this older family member. She was happy she was at home. That's describing how things were before. That goes with the state's theory as it was presented. The next part talks about the after, which is also consistent with the state's theory. So when we look at it, we have to look at it as a whole. Was the jury asked to deviate from the evidence in order to return a conviction? And that didn't happen here. The statements were not used repeatedly. They were not part of a sinister motive to obtain a conviction through compassion or through sympathy. It was not planned and calculated to result in prejudice to the defendant. It's not possible in a criminal case to completely divorce yourself from the victim. Where the problem arises is when the comments are designed to divert the jury's attention from the evidence to obtain a conviction based solely on that sympathy. And that's not what happened here.
And look at that change that occurs from that attack. Look at how different that life become. Why isn't that going to the sympathy of what occurred, not to the victim, but to the family, and adding that into the equation on what they're to consider?
I think at that point, the cold record hurts us there. Tone could certainly make a difference.
Right.
I think generally they're just trying to draw a distinction. Look at how that changed, as opposed to an impassioned. Look at how that changed. I don't think we can suppose that there was a plea for compassion, a plea for sympathy based on the cold record alone. We have to look at everything in its entirety when we're looking at a prosecutorial error case.
And doesn't the continued comment about how he took away how she wanted to live at the end of her life, doesn't that weigh toward more of a sympathy factor than even beyond the cold record?
I would say no. I would ask you to consider the only mistake I would ask you to consider in this case is that she did not get to live out her final days on her terms. That's a fact. She didn't get to live out the final days on her terms because the defendant took that from her. And that's what the evidence established throughout.
But isn't that a fact that's only relevant to sympathy?
I don't believe so, because the fact is what resulted in her death. And if we wanted to look at the remarks that counsel is making, that she had some sort of control over this, she didn't have any control over how she lived out her final days. It was the defendant. So it goes to the piece of who's responsible for taking her life from her. And that responsibility goes to the defendant. Even if this court were to find error, the state would still support or still argue what it set forth in its brief, that we can still satisfy the Chapman standard, in that the properly admitted evidence established that an individual forcefully broke into her home with the intent to rape her, that she suffered brutal injuries as a result of that rape that resulted in her death, and that the DNA evidence that was tested in this case directly linked the defendant to that offense. Even with the challenged remark, the evidence was sufficient to allow the jury to still conclude that the defendant was responsible for each of these charged offenses. If there are no further questions from the court, the state would respectfully request that the decisions of the district court and the defendant's convictions be affirmed.
Any more questions? Thank you, counsel.
Your Honor, I have no further comments. I would waive my rebuttal.
I want to
Unless-
follow up on the jury instruction exchange. exchange that I just had with counsel. Is it your opinion, or is it your view that the race switching jury instruction was factually appropriate?
Yes.
Why?
I don't think it matters whether or not race was an evidentiary issue in the trial. You can't hide the color of someone's skin when they're sitting in the room in front of you at the defendant's table. And I think if you are asked to make decisions, like whether or not a cause occurred or whether or not he had certain intent at the time he entered the house, all the decisions that the jury had to make in this case. And if it's a close call and you're sitting at him and you have racial bias in you, maybe that sways your decision one way or another. And that shouldn't happen. And that's why anytime you have the defendant and the victim with different races, then that decision or that instruction is factually appropriate.
So it would be your position that if a jury instruction is both factually appropriate and legally appropriate, that it's error not to give it?
Yes.
And so we're into constitutional error land.
Yes.
And that would be true even if the judge made a determination that some of the other instructions got to the same point.
I do think so. I think that's the analysis that this court has set forth is just that.
Why would that instruction ever be legally appropriate?
Why would it be legally appropriate?
Right.
I think the Supreme Court, United States Supreme Court, has made comments that are cited in our brief that talk about the importance of eliminating racial bias and prejudice from our criminal justice system and eliminating that as a basis for any type of verdict.
Well, accepting that as a laudable goal, I'm not sure how these kinds of instructions further that goal. In other words, I mean, I can easily imagine a scenario where this kind of instruction might be used to inflame bias as opposed to cure bias. And so does the remedy fit the problem?
I think in this case, the instruction does do what it purports to do, which
But
is...
I'm just talking generally. If it's legally appropriate in this case, it's legally appropriate in any case. I mean, that's the question is, should this instruction ever be allowed? Because it does draw attention to these racial issues, which can cut both ways.
Certainly, but I think you can't... the racial issues are going to be there whether or not the instruction is given. The instruction aims to reduce those, and I think...
Well, why is this the proper time in the proceedings to address that? You have voir dire, whose sole purpose is to select a fair and impartial panel of jurors. Mm-hmm. And why isn't that the time in the proceeding that you address racial bias rather than, I mean, it seems like in country vernacular, you're closing the gate after the horse has escaped if you're waiting till closing argument to deal with jurors that have a racial bias.
I don't think so, and I think the reason is because the existence of implicit bias. When you voir dire potential jurors, you're asking them whether to explain their explicit bias and to tell you whether or not and to report these kinds of things. But a lot of people have prejudice that they don't necessarily label or admit to or even aware of. And so I think giving this at the close of the case and asking them to switch those draws out that any hidden prejudice or implicit bias that the jurors may have and to eliminate it from their decision.
Here's what's troubling me. Well, first of all, this comes from a Minnesota Law Review article, right?
Yes,
that's where it came from. There's no other court in the land that's dealt with this particular instruction, right?
I know other courts have dealt with similar instructions.
They've dealt with instructions having to do with racial bias.
Yes.
They have not asked the jurors to engage in this exercise. That comes from the Law Review article, right?
I don't know. I don't know exactly the instructions considered by the other courts. So
it just seems to me extraordinarily naive to think that this exercise is really going to solve the problem of implicit racial bias. Do you have any response to that?
Maybe so, but does it, is it harmful? Is it, if it
My
has,
colleague's suggesting that it could be, that if
and
you-
I suggest that it's not.
that there's no way for it to ever inflame racial prejudice to give this instruction. Is that your position?
No, I think the analysis is whether it's legally appropriate, and I have explained why, and I think that it's also factually appropriate, and I've explained that.
You
why.
have transformed United States Supreme Court cases in distinguishable situations about the evils of implicit bias, which I think no one in the room will disagree with, into a legal mandate for the giving of an instruction. So how do you make that leap?
If the issue is important, it needs to be addressed. Certainly, an instruction addressing that.
I understand that it needs to be addressed, but does it need to be addressed by an instruction in a criminal case at this juncture in the trial?
I think what we have is a requested instruction, and that's what we're forced to look at. And when it's requested and the defendant wants it, and it goes towards this overarching goal, and I can't think of a reason not to give it, and then I think yes, it's legally appropriate.
Thank you.
Any more questions? Thank you, counsel.
Thank you.
Thank you both for your arguments this morning. Court will take this matter under advisement.